Bill Henshaw here again, Constitutional Crisis Channel. This is kind of an update on my South Carolina case, and there hasn't been any real news of the type I would like to report. But I've been thinking from day one, and I mean from last year when I sat in that damn jail there for 5 months in Columbia and 7 months overall. And you got to say to yourself, are these people that damn stupid? I mean, my goodness, took them 7 months. And my answer to that question, with two exceptions who I'm not going to name here, they're going to find out in the fullness of time. But most of them can't be that stupid, especially that high in the South Carolina government. You just can't be that stupid and hold those jobs. But I thought from day one, and if I didn't make it clear, I'll just mention it briefly here. On my way from coast to coast, it took 32 days. 5 different prisons, 3 federal military airplanes. I was in federal custody the entire time. And yet I had been arrested on a felony fugitive no bail warrant in South Carolina, a jurisdiction which I had never been in until March 2nd of last year. Now that's a real neat trick, and that's one of the questions they would have had to answer if we'd gone to trial. If I'd never been here, how the hell could I commit a crime that your court has any jurisdiction over, even if? I mean, it's ridiculous. But what I think was going on was that the feds kind of convinced South Carolina to do their thing and arrest me while they did their own investigation in the background, trying to find goods they could get on me to make me out to be a terrorist or a white supremacist or this, that, and the other. And I think that's why I was in federal custody for as long as I was. And every stop I had along the way, right here from Redwood City all the way to Columbia, South Carolina, every time I arrived in a new jail, I was asked, "Why are you here?" And I said, yeah, that's a good question, and one they could never answer there, by the way, and one they had to let me go eventually, because they couldn't figure it out. But everyone asked why, because they could find nothing on me, and the feds clearly, if they did the investigation that I'm suggesting they did, they couldn't find anything on me either, especially if they checked like militia websites and things like that. That's not what I do. I'm not at that point where I think we have to go that route to be able to invoke rights secured by the Constitution, and I hope it never gets to that stage, because if it does, we might be looking at a repeat of Tiananmen Square here in the United States. And I don't know, can that happen here? One would certainly hope not, but I'm not betting against it either if I'm in Vegas making odds. And all you have to do is look back to 1970 to Kent State, when you had college students there that got shot down by the feds for protesting the Vietnam War, a subject matter for a different video. But this makes sense to me, that this investigation took long enough that they convinced South Carolina to keep me in custody until they satisfied themselves they had nothing on me, and at that time they decided to quit. Now I will say, in the intervening time frame, the 18-page hand-printed writ of habeas corpus I sent to the U.S. Supreme Court may have had a lot to do with that too. And by the way, this is over a year later. That has never even been acknowledged by the U.S. Supreme Court, let alone answered. But it got there. And I'm sure they haven't seen a writ like that ever, as far as the 20th century is concerned. But I go back rather a bit farther than that. I go back to 1792. When I'm talking about a writ of habeas corpus, it's not the statutory crap that they see in these courts, so commonly these days, and we'll have a whole separate video on habeas corpus, what to avoid, which is the statutory writ, 28 U.S.C. 2254. Want nothing to do with that one. In any case, that's the only thing I can think would have kept me there that long, and in effect the feds left South Carolina holding the bag, and it may be a considerably big bag by the time I get through with them. And that's the kind of news I want to be able to report to you soon here, if I possibly can, because if they can get away with that, there's no hope for any of us. With the record that my friend and I set in their own court, my goodness, it's absolutely stunning what we were able to do. And they have no defense for it. They have no immunity. And that's what I want to teach you to be able to do. The same thing, and with a lot less time and effort than what it's taken me to do it. So if we can get that far and we start sending them to jail, how many of them do you think it will take? Now, continuing my video on South Carolina and what I'm saying about helping you to do it, you'll find that I currently have packets of documents available, very reasonably priced, that you start using these and asking questions like this, they're going to start to run away from you just like they do from me, like you turn the light on in the kitchen with a room full of roaches. So you'll see that I have available documents for use in the trial quote-unquote court. I have a set of document packets available for appellate purposes that, by the way, can be used in the trial court if you have in mind to make any motions in the trial court, something I don't do, but they can be used there equally well. And I have a separate packet now on subpoenas. And this is where we really stick it to them, because if they're going to stand there and not even acknowledge our demands for bill of particulars, let alone answer them, and tell us what the jurisdiction is, what the rules of the game are, and what the elements of the crime are, they're saying, in effect, that you have no right to put on any defense, let alone a meaningful and substantive one. That's going to be too much even in the corrupt justice system we have now. It just is. They simply can't do that. But if they're going to do that, then the only other option we have is to subpoena the responsible parties and ask them in front of an inflamed jury, hopefully, why didn't you properly train your law enforcement officers to know the meanings of the terms of the statutes they're enforcing, so that they'll know, for example, that you and I are not a person required to have a driver's license? Why didn't they teach them that? Wouldn't that have been real nice to do that, especially since we can sustain our position and they can't possibly prove that we're a person of that type? Just one example that you can see. So you get them in there and you ask them questions like that, and see, now you're cross-examining and confronting your real accusers. That's the other ace up our sleeve that we have. And even though that's a Sixth Amendment issue, and I don't like to use the first 8 amendments, that's a hell of an argument in this context. And what I do is I always say the unpurviewed Sixth Amendment, meaning that it's not being applied to states because we're not in states. And we can use the first 8 articles of amendment in that context. Although, as you'll see from reading my documents when you get them, I think we have much better issues to raise under all 6 articles of the Constitution for the United States. If we start doing that, now we distinguish all this 14th Amendment case law crap. They can't use it against you because it's not relevant. And again, going back to the Supreme Court of Nashwander, and we'll be doing a video on this, but Rule 2, the court says, I read exactly, that the court will not rule upon an issue of constitutional law any broader than is necessary for the precise facts to which it is to be applied. So if you're not arguing 14th Amendment case law crap, then the other side can't use it against you. It's not relevant. I can't tell you how big that is when you get documents and see that when the light comes on, and it will, say, oh my God, why aren't we doing this? And you can do it easily and effectively, and with a little extra assistance from me from time to time. You have to do some light editing on some of the documents, but not a big deal. But you start going in there with these things and you do it before the arraignment, now you're going to have what happened to me happen to you, but they're going to get you out of there as quickly as they can without getting anything on the court record that will convict them of treason. This is the power that we have if we use it properly, and what I want to teach you to do. Thank you.